Thank you, Attorney General Garland. At this time, we'll start the questioning period. I'll open by recognizing myself for 5 minutes of questioning. I want to start with civil rights and in particular voting rights. I'm 60 years old, Attorney General Garland, and for almost my entire life, what was normal in the United States was that if a jurisdiction wanted to change its voting laws, it had to get pre-clearance from the Justice Department or the District Court in the District of Columbia. That was because of the Voting Rights Act of 1965. Now, the Voting Rights Act of 1965 came about largely because of the efforts of our dear departed colleague, John Lewis, and his efforts that culminated in Bloody Sunday in Selma, Alabama in the spring of 1965, and it led to the passage of that bill and into law in August. That was sustained by the United States Supreme Court in South Carolina versus Katzenbach the next year. And it has been called one of the most effective pieces of civil rights legislation in American history. In fact, that was called that by the Justice Department in 2014. All of that was upended in 2013 by the Shelby County decision, which all of a sudden invalidated the pre-clearance requirement. So now, instead of normal, what we have is the Justice Department has to file suit every time there's an unconstitutional change in voting laws that offends the 15th Amendment or some other part of the Constitution. And as a result, your Justice Department has to spend a lot more money filing lawsuits to reverse these voting law changes. Am I correct in that? You're muted, sir.
I'm sorry, we'll try to get the technology better. This is my first virtual hearing. Yes, you are correct. Shelby County invalidated the coverage formula, which permitted the pre-clearance program to continue. So it is now the case that the Justice Department is largely limited to bringing affirmative cases in which it finds under Section 2 of the Act unconstitutional practices or procedures with respect to voting that discriminate against the race. This does require us to bring individual cases. That is a much more time-consuming and more expensive process.
In fact, what it does is it reverses the burden of proof. It was normal during the vast bulk of my lifetime that if a jurisdiction wanted to change their voting laws, it was a jurisdiction that was listed as among those having traditionally and historically violated the Constitution for voting rights. The jurisdiction like that wanted to change its voting laws, you know, to make people guess how many jelly beans are in the jar, or to enact sweeping purges of voting rolls, things like that. They had to get pre-clearance. They had to get permission from the Attorney General. And so the Attorney General was in control of that. Now it's all flipped on its head. The Attorney General has to file a lawsuit and carry the burden of proof, which could involve months and months and even years of litigation to invalidate, a Jim Crow kind of a voting law change like that. Am I correct, Attorney General? You're muted again, sir.
Am I mute now?
I can hear you.
Okay, thank you. I'm sorry, I'm just get back to the question. You are correct that the burden of proof is now on the Justice Department to prove in each individual case a violation of the Voting Rights Act.
Well, what we're here to talk about are resources for your Department of Justice. What does that mean? If we have any hope of preserving voting rights in the parts of this country that historically discriminated against African Americans and others on the basis of race for voting rights. If we have any hope of combating these changes, that are being enacted vigorously now in the United States, how much money is it going to cost the American taxpayer because of that Shelby County decision?
The right to vote is absolutely fundamental. It is the cornerstone of our democracy. The Justice Department is pledged as part of its original purpose in its establishment during Reconstruction to protect voting rights. The 1965 Voting Rights Act gave us additional authorities, one part of which was removed as a consequence of the Shelby County case. We do now have to bring each case individually, and you are correct, that is a very large investment of resources, and that's part of the reason why we're asking for the 15.8% increase in the budget for the Civil Rights Division.
Well, I thank you for that, and I yield now to our distinguished ranking member, Mr. Adderholt, for 5 minutes of questions. Let's gavel back in and resume our hearing with the Attorney General of the United States. Mr. Attorney General, I'm going to recognize myself for 5 more minutes of questions, and we'll begin our second round. I know you are acutely aware of the security needs of the federal judiciary. Last summer, we saw the shocking attack at the home of Judge Esther Salas in New Jersey, resulting in the death of her 20-year-old son and the wounding of her husband, a horrible incident by any measure. And in fact, it was found out later that the perpetrator was an anti-feminist extremist who had plans to conduct a similar attack on Associate Justice of the Supreme Court of the United States, Sonia Sotomayor. The Judicial Conference of the United States has noted significant concerns about the physical security of courthouses, that judges and courts are the targets of higher numbers of serious threat communications, and related measures indicate judiciary security is at greater risk. Do you agree that the federal judiciary faces a more dangerous security environment now than it has in times past?
I do, Mr. Chairman, and as you mentioned, I am acutely aware of this. I served when I was a judge on the Security Committee of the Judicial Conference of the United States, and I served as the chair of the Executive Committee of the Judicial Conference. And in both positions, I and the conference as a whole is extremely concerned about judicial security. I think with the rise of domestic violent extremism, judges, as is true of many other government officials, both in the federal and state governments, are becoming more likely to be targets. So this is something we have to be very, very concerned about.
Well, having said that, Attorney General, could you share how the Justice Department, particularly through the United States Marshal Service, can improve security, and whether there will be more judicial security resources in your fiscal year 2022 request?
Yes, thank you. You are right. It's the Marshal Service who are responsible for the protection of the federal judges. The fiscal year 21 budget included an additional $7.4 million for Marshals intelligence to use looking at open sources for threats and to expand their intelligence unit, and another $4.4 million to modernize the home intrusion security systems that Congress authorized a while ago for each federal judge. The specifics of the FY22 budget are not yet available, but they will include money for judicial security.
Well, thank you for that. We had a short discussion earlier about illegal drugs. Now, the Department of Justice devotes significant resources to reduce the impact of drugs on society. On the enforcement side, in fiscal year 2021, your overall DEA and federal organized crime and drug task force funding is just shy of $3 billion, with almost $400 million for grants under the Comprehensive Addiction and Recovery Act. Question is, how will the department ramp up efforts under your leadership to reduce the damage from prescription opioids and synthetic drugs?
Right. So this is a terrible scourge on our society. The consequences of prescription opioids, and we are spending currently $9.5 billion really across all of DOJ on all drug enforcement issues, which include diversion of opioids. DEA is working with FDA to limit the availability consistent with the needs of medical practice. But a significant part of this is not just law enforcement. A significant part is also in the president's budget, but not for DOJ, but for HHS, some $394 million in grants under the Comprehensive Addiction and Recovery Act as well. So there is a significant amount of money on both sides of this issue, protecting from a law enforcement point of view, and then helping addiction recovery.
Thank you. Well, Attorney General, in your view, what are the largest challenges still facing the department in its efforts to address the American opioid epidemic?
I'm glad you gave me an opportunity, because I think I mixed up the programs I was talking about. The president's budget with respect to the opioid problem for HHS is an increase in $3.9 billion. So I've got my decimal point in the wrong place, for which I apologize. It's a pretty big number. Those are the two kinds of areas in which we're trying to work here. One on the law enforcement side, and the other on the health side, and the relief for people who are addicted.
Thank you, sir. My time